Yeah, please. Lordship, can I be taken up tomorrow, Lordship? Because due to change of officers and all, Lordship, they are on process.
Tomorrow.
Tomorrow, Lordship.
Okay. Both sides are represented. Referring to the order dated 27/5/2024, the learned Mr. S. Tapin, learned senior government advocate, praised for taking up the matter on 30/5/2024.
Lost.
Clear or not? List of 30/5/2024.
All.
Before I proceed, I tried to serve notice on the counsel who had appeared in the writ petition, but he has refused to accept.
Okay, refuse to accept. Okay, then you please proceed. What is the name of the learned counsel who appeared?
C.W. Mantawar.
Okay.
In fact, my lord, I had sent the PDF copy through WhatsApp also. I had got the printout of the screenshot. I misplaced it somewhere. I'm sorry.
Okay. You need a security.
Sorry, madam.
You need a security or a secretary.
Ma'am, my lord, the writ appellants are challenging the interim order dated 17/5/2024, passed by the learned single judge in writ petition number 195 of 2024. By this impute order, my lord, the learned single judge has stayed the order dated 29th of April 2024, passed by the Deputy Commissioner, Tirap District, disqualifying the writ petitioner under as member of Jilla Parishad member under Arunachal Pradesh Local Body's Prohibition of Defection Act 2003.
Where is the law? We don't have that.
Where is that law?
Law. AP,
Act.
AP Code Volume 7.
AP Code.
7.
8. Volume 8. Sorry.
8.
8. Okay.
Page number?
Page number 175.
175.
After delimitation of panchayat system into two-tier system, there have been certain amendments which I will indicate.
Arunachal Pradesh local authorities prohibition of defection.
Yes.
Which provision? 5(2).
Now, the legal provisions which would be relevant in my case, section 3, 5, and 6. Broadly, section 3 stipulates 3 situations where a member becomes liable for disqualification for defection. However, section 5 is an exception to section 3. In case of merger under section 5, the grounds for disqualification under section 3 is not applicable. But, my lord, to constitute a valid merger, there has to be a required quorum of 2/3 members. That is there. And section 6, my lord, provides the procedure for lodging a complaint for disqualification under 3. The said provision also empowers the Deputy Commissioner to decide the question, madam. May I read the relevant provisions, madam? Section 4 has been omitted, madam, by subsequent amendment.
4 is not there.
4 is not there, madam.
where is the order which is under challenge
Page
before
number
the single
127.
judge? Page,
Before the learned single judge.
Sorry, Miller.
Before the learned single judge.
Page number 127.
127.
That is the, yeah.
No. The order under challenge before the, in the writ petition.
Miller, that order, my lord, will find it page number. Seventy-one.
Mr. Tapin, you see, in this volume 8, please come to section 6.
Close.
Please read that slowly. Please read that slowly so that we can also understand.
A complaint that a member has become subject to disqualification under section 3 may be made by a member or a political party to the member secretary of the concerned local authority.
So number 1, page 71 shows that a complaint was made.
No.
Correct. Now next.
In a case falling under clause 1 of subsection 1, after a member gives up the membership of the political party. If he gives up the membership. In a case falling under clause B of the subsection 1, after expiry of 15 days. It's about the subsection 1B. They in case falling under subsection 2 after he joins the political party. This in present case attacks this one also.
Okay. Now two.
Where a complaint under subsection 1 is received by the member secretary of the concerned local authority, he shall within 24 hours from receipt of such complaint refer the same for decisions to the state. It is lawsuit deputy commissioner law. Now it is amended lawsuit.
Amended.
Who shall decide the question
Okay,
within
okay.
30 days after
Okay.
receipt by him of the reference and his
No,
decision.
these amendments are not incorporated in our books. So we
Laws.
don't know.
Here also it says election commissioner. It has been now amended. It is deputy commissioners.
It is
The
there
deputy
in volume
And
9.
accordingly, in present case also, it was referred to the deputy commissioner by the member secretary, and deputy commissioner has taken the decisions.
Is there any rules framed under this
No.
act?
No, my lord.
There's no rules.
Rules is not found also.
Okay. Can you get the scan copy of the records to see how the matter proceeded before the deputy commissioner, the note sheet or something?
That is, let's say, basically the principle of summary procedure is followed, let's say. And yes, I think there's no laid down any procedure. Anyway, I can take instruction from the
Amendment, volume 9, page 178.
volume 9.
Seven, eight. Volume 9. 178. 178.
So that part, I'm not. No problem. Correct, yes. Correct. If lawsuit otherwise see that the issue order here lawsuit. The region is not actually, the decision is not supported by the region law. What I see. Even the objection raised by the lawsuit, government and the private respondent lawsuit has not been considered, though it has been reflected. That also has not been considered lawsuit. It's lawsuit see the impugn order. Lawsuit. Because that order was passed by me lawsuit. The impugn order in the writ petition. Basically, what happened lawsuit? In every case lawsuit, when any trial summary or lawsuit, digital procedure lawsuit, when the matter is admitted lawsuit, basically lawsuit trial doesn't occur until unless lawsuit court decided trial is required lawsuit. In the present case lawsuit, the petition, writ petitioner lawsuit, he belongs to lawsuit INC lawsuit. He joined lawsuit BJP and he moved no conviction motion against the chairpersons who belongs to BJP lawsuit. So their complaint was lawsuit. Because to join from BJP to INC to BJP lawsuit, 2/3 is required lawsuit. INC they have only 2 members lawsuit. So 2 members, one doesn't lawsuit constitute lawsuit 2/3 lawsuit. That is the issue here.
For the purpose of moving a no confidence motion,
Lawsuit.
what is the minimum quorum required in a Zilla Parishad?
For no conviction motion.
Huh?
1/3.
1/3 lawsuit.
What is the total strength?
10 lawsuit.
10.
10.
So that means 7.
7.
7.
To move law 7 is satisfied lawsuit.
Against this interim order, we are not inclined because of the fact that a question of natural justice was examined by the learned single judge. So we are not inclined to entertain this intra-court appeal only in respect of the interim order because there is another fallout. If we entertain the writ petition, neither the writ petition would move and nor the this proceeding which has already been undertaken by the deputy commissioner will remain in the limbo. It won't be given effect to. You see, we can't permit the challenge to be entertained and render the matter infructuous because if we don't state this learned single judge, we do not state it, then what is the purpose of entertaining a writ petition?
Well,
Yes.
that proceeding before the deputy commissioner had reached a logical conclusion. That is how she was disqualified.
Not understood. My lord is saying that if the honorable judge had not stayed that order, then it would have resulted in the required the implementation of the order passed by the deputy commissioner. So what would have been left in the writ petition to decide? That's what the query is.
No, there's another aspect of the matter. The learned single judge, while passing the interim order, has come to two conclusions. Firstly, that there is a violation of principle of natural justice, and second, that the grounds on which the writ petitioner was disqualified are not germane, meaning they are not irrelevant. Well, the ground on which, in my respectful submission, the writ petitioner was dismissed is a ground provided under subclause A of subsection 1 of section 3. Therefore, that very finding is erroneous.
Sir, I'm just trying to understand. Let me put it in this way. For some reason, we are not inclined to grant an interim stay. And we give our reasons that we are not inclined. Now, according to you, that observation of the court is a final and binding authoritative pronouncement of the court. And therefore, when we hear we finally hear the repetition, are we to understand that we cannot allow the repetition? For example, somebody comes for bail. We say that interim bail is we are not granting, but we'll examine the what you call the trial court record and the case diary, and then we'll consider your application for bail. So if initial stage we say no, would it mean that at the final determination, you can't say yes?
No, absolutely.
Then it's merely an observation. We request the learned civil just to expeditiously hear on if required by giving a within a out of turn hearing after hearing as early as possible. Just a query, this, under this, local acts, this, Zilla Parishad, whatever act is there applicable. If once a no confidence motion fails, second motion can come within what time? Is there any time limit for the second motion?
Yes,
Or there
yes,
is-
yes, no, yes,
There's no,
No.
there's no time limit,
It's
so it
not
can be, immediately thereafter.
yes. In law, it's not prescribed.
It's not
No, no.
prescribed. Still- Then Mr. R.L. Thungon, counsel for the appellants, as well as Mr. S. Tapin Leonard, senior government advocate,
1 and 3 laws.
appearing for respondent numbers 1 and 3. Next paragraph. It may be mentioned, appellants S, huh? It may be mentioned that the learned counsel for the petitioner, appellants had submitted that he had intended to serve a copy of the memo of appeal to Mr. C.W. Mantau, learned counsel for the private respondent numbers,
4, Madam.
respondent number 4. Who was the petitioner in the connected WPC 195 of 2024. Always here. Because under explanation C of Order 3, Rule 4 CPC, the mandate of appointment of a counsel in a proceedings would deemed to be continued. Stop. The corresponding Inside. Inside. Bar Council of India rules. Bar Council of India rules. Bar Council of India rules. And corresponding provision is also contained in Rule 782 of the Civil Code Rules and Orders of the Guwahati High Court. Full stop. Full stop. Next. By filing this intra-court appeal, the appellant has assailed the order dated 17/5/2024, passed by the Learned Single Judge in WPC 195 of 2024. Most of the appellant is aggrieved by the interim order passed therein, by virtue of which the operation of the order dated 29/4/2024, passed by the Deputy Commissioner, Tirap District, Khonsa, was suspended till the returnable date. Exceeding the grant of stay, the learned counsel for the appellant has submitted that the interim order was passed on by assigning two reasons. Firstly, it was held that the grounds on which the petition by the by which the writ petitioner was disqualified appeared to be not germane. And secondly, the order of disqualification was in violation of the principles of natural justice. Full stop. Next, by referring to the provisions of section 3, 5 and 6 of the Arunachal Pradesh local authorities within bracket prohibition of defection bracket close act, 2003. It was submitted that under the scheme of the said provisions, there is no express provision for providing an opportunity of compliance of natural justice. In view of the mandate of subsection 2 of section 6 of the said act, it is provided that on a complaint received by the member secretary of the concerned local authority under subsection 1, within 24 hours, the matter is required to be referred to the Deputy Commissioner, who is required to decide the question within 30 days after the receipt of the reference by him. Next one. The learned senior government advocate has submitted that although the learned senior judge had recorded his submission, but the said submission was not considered while passing the impugn order. Next one. Be that as it may, we find that as per the impugn order dated 17/5/2024, the notice issued to the respondents was made returnable in 2 weeks. First of all, therefore, the estimated returnable date would be on 31/5/2024. First of all, we have also considered that if the writ petition is admitted for hearing, then there is every likelihood then that the proceedings of the writ petition would be further delayed. Therefore, any delay in the disposal of the writ petition may prejudice the interest of both sides. First of all. Next, upon such consideration, we are of the considered opinion that instead of entering this intra-court appeal, it would meet the ends of justice to request the learned single judge to make an endeavor to hear and dispose of the writ petition as early as possible by curtailing unnecessary adjournments. Next, we also make it clear that as we have not examined the issue raised by the learned counsel for the appellant on merit, all issues are left open to be decided by the learned single judge in accordance with law. Next, on a prayer made by the learned counsel for the appellant, we grant liberty to the learned counsel for the appellant to make a mention before the single judge for the listing of the matter on 31/5/2024. With this observation, the appeal stands closed. Private respondent,
You will be paid for private respondent.
No, not.
so you appointed a amicus curiae.
Yes,
Respondent number 2,
in terms of section 40, legal aid council.
legal aid counsel. Suggest a name.
Well, I would like to point out one thing. The difficulty of appointing legal aid counsel, most of the legal aid counsels are they are practicing in the subordinate courts. Now, many a times they don't turn up to appear in this court. And then the Bar Association, I think Lordship Surana was there, opposed that Jagjit Singh judgment. We had a meeting there. In the old High Court building, a panel of advocates list was given that these particular, they will deal with this, and this list is no more implementing here. And the young boys and girls are appointed as a legal aid counsel from the legal service authorities. And many of them, they are not competent to deal with the murder cases.
There's a list of panel lawyers,
From
for
our,
high court panel lawyers. Yes.
Itanagar bench, the names are Jungkam Jini, Nani Anju, Nikita Ranjan, is Jaya Doji, is Oyam Bingep, and Miss Sue Valentine Darang.
this
These are for the High
except
Court.
for Miss Dangin. And then my younger, that Mr. Jini, Yumgam Jini, has been appointed as special public prosecutor NDPS for the district and session court UPR. And the rest, all of them are from the lower court only. They are practicing at session court.
We should bring them in.
We have requested them, and even they don't see the cost list of High Court sometimes. That is the greatest difficulty, Milord.
Miss Nikita Dangin is regular here.
No, Nikita is also having a lot of cases now as an legal aid
We
counsel.
don't have an alternative because if people don't come forward for empanelment of their names,
Yes.
we can't do anything. Let me appoint Ms. Ranjan,
Anyone.
because there's a requirement of law. It's a
No.
mandate.
Actually, Milord, that Jagjit Singh judgment has created this problem. That was
That's
relating
not a
to
problem, that's a
that
solution.
was relating
That's
to
not
a
a
bail.
problem. That's a solution. You see, the
It's statutory right.
reason is very simple, but because you see, when we are envisaging a system, you see, there's a departure in the earlier mindset and the present thought process. Now we are saying that not only this is a what you call fundamental right of the people to have access to justice, but we also say that it's a sort of service that we have to provide. Therefore, if a person can't come for various reasons to defend a prosecution for appeal against the conviction under POXO Act, then it's the duty of the state to provide that. That notice was duly served on the respondent number 2 / informant. To stop. None appears on call for the informant. However, Mr. G. Tatu Leonard, APP for respondent 1 is present.
That's it.
And he suggests that legal aid counsel be appointed for the respondent number 2 / informant.
Next week, I'm straight, no? No, Milna, no.
Accordingly, we are inclined to appoint Ms. Nikita Ranjan as legal aid counsel to represent the respondent number 2 / informant. Paper book is ready. Paper book is ready.
Milord,
Paper book is ready.
paper book, I am not aware because normally they takes time, Milord. At least 7-8 weeks, they takes time, my lord.
As the LCR is, as the TCR, trial court record is available, comma, the registry shall expeditiously prepare the paperwork. List after 4 weeks.
My lord, this IA can be listed on 6th.
No, IA, let the paperwork be prepared because you have to go through the evidence.
No, my lord, that this is for the IA. I'm praying for suspension of the sentence.
I understand. Let the paperwork be prepared. So
No,
that
no,
we
no,
can-
no, my lord, paperwork preparation is another thing, and disposal of the IA is another thing, my lord.
No, but we'll have to look at the evidence. For the purpose of, for that purpose, we have to look to the evidence. We'll have to examine the evidence. In a offense where the with the sentences under POXO Act.
My lord, still, may I only request, my lord,
We will definitely take it up.
I'll make an attempt on 6 for suspension of the sentence.
6 example was which the people to. PCR form of this thing.
Time like yes.
No, we'll
It
have to wait
takes
for 1 month. We should prepare expeditiously as the learned counsel for the appellant is also pressing for the prayer for suspension of sentence in the connected application. Full stop. Give a date after 4 weeks. List on so and so. In the IA, you write the Mr. T.T. Tahal, counsel for the appellant, prays for the prayer made in this interlocutory application for suspension of sentence. Full stop. In the connected appeal, you pass an order for expeditious preparation of paperwork. Full stop. List,
On 6th, my lord.
no. Same date. Because the paperwork will be there, they will be preparing it, so we can't examine the records. We have our limitations.
Yes.
List on so and so. Next, the registry shall make an endeavor to prepare the paperwork by them. You see, here there is another reason. The victim's statement about the nature of assault made on her is very explicit. He has, she has described in the manner in which the assault took place.
My lord will have page 99 of my IA for a moment. I will demolish this view, my lord. Kindly have page 99 for a moment. Of my IA, my lord, page 99.
Yes,
On, my lord, my client went to the house of complainant on 1st October 2018, my lord. And in her cross, she says, before 26th of January 2018, she has witnessed the victim waiting the bed. And this problem was already there, my lord. It is not the case that it is a new thing that I have done, my lord. And my lord, at page 103 and 105, my lord, kindly see that Dr. Lima Rangu, his medical legal opinion, my lord.
yes,
And my lord, kindly see page 106 and 108, FSL report. everything is intact. At the most, my lord, this can be a case under section 7, either 8. In the worst case, it can be section 12 of the POSCO Act. My lord, when this appeal was admitted, the order recorded was LCR shall be retained to dispose of the IA for suspension of the sentence. Something like that.
Okay. My brother says it may be taken up tomorrow. Okay, just say
Great.
interim application. Application was so that will be listed tomorrow.
Great.
Huh? Criminal appeal? In the criminal appeal, also change that order, where we have said 289 and the application for suspension, that we removed. Only expeditious preparation of paperwork. And here you say that you want to have access to the LCR, you can take it in.
Yes, your lordship, I have gone through the record and close hearing with the petition.
He has a record.
Okay.
Here, your lordships,
No, you're not hearing it now. You're not hearing it now, but we say that if you want this TCR to be consulted, you can look into it. You take it up tomorrow.
your lordship, my humble prayer will be, wait, no,
let
my
me
humble,
understand.
my humble prayer before this court is that this IA and main appeal may be taken up together and matter may be expedited so that if nothing comes out,
No,
then
but that he has objections. That's why we are taking it up.
We hear you.
IA is a suspension of sentence under 389. Jagdish Singh case also speaks about the participatory right of the victim in the
Oh, yes.
It's also,
Yes, yes.
yes, it also includes that.
Okay, okay.
So we need more time.
Okay,
Earlier.
then the earlier order stand.
Remember, letter judgment also.
No, it's okay. Once an objection is taken, that means Ranjan appeared for respondent number 2. She is right.
My lord, may I just beseech the court, kindly, for disposal of the suspension of the sentence,
You have to wait.
because
You can't-
that paper book, my lord, will take some time for preparations. Therefore,
No, it
my
will
lord,
not.
I request, an innocent soul is inside the jail.
It's okay, we take into
And,
that
and
consideration.
my lord, with greatest respect and humility, it is my perception, my personal considered opinion in such kind of cases, my lord. I'm making it official also, my lord, that these kind of acts, laws are not a gender neutral, my lord. Because many innocents are punished in such a way,
No, you see, there's a, the.
even the facet of Article 21 of the Constitutions are almost taken away. my lord.
You may be right, we don't say that you're wrong, but the fact is that when we are appointing a amicus curiae and the objection is raised.
Well,
So we have to
technically,
give an
well,
opportunity.
I have to bow down before
we
their
have to
lordships
give an
because
opportunity.
technical aspect, I
Presumption of innocence does not exist after convictions.
procedures.
Please don't perpetrate.
My lord, can it be on 6th?
No, because she must be given paper, otherwise she will not be able to represent.
My lord, when is the next date? Huh?
Date we have already given.
Then everything will be on merit only. I'll demolish my case, demonstrate my case in this manner.
Next.
Probably also. Well, at the first place, their lordship would be putting a question to me whether there is a live issue or not. You know. But to my understanding on the fact of the case is that, yes, there is a live issue because a deputy commissioner without the approval of the cabinet, my lord, by means of a policy decision, cannot afford to seat the office where the district hospital Calico Pool was taken over. My lord, I just my book is there. Well, this document is not available. Somehow I manage this. Tagum is there, no? Yeah, I don't know about this. Yes, I don't know.
तो ग्रेट हुआ है मालूम है ये जो हेडक्वार्टर का ग्रेट हुआ है मेंशन क्या क्या लोग नहीं हुआ है लेकिन न्यूली है ये डिस्ट्रिक्ट ओपन हो गया था तो ऐसे जहाँ में इंटरेस्ट रहे वो है सब इनिशियली शिफ्ट किए रिटर्न अवन पे अपग्रेड हुआ वो नहीं है सिक्योरिटी का निकल
Well, I have given that business allocation rules for a moment. Now, Milord, the basic contention, Milord, I am raising is by means of an administrative decision by a subordinate officers cannot override the decision taken by the cabinet, Milord. Being a subordinate officer, Milord. So therefore, this 19, Milord, 87 rules of business allocations, Milord. Now, my lord, immediately will refer to Article 162 of the Constitution of India, extent of executive power of the state. My lord, law is well settled that policy decision, court will not exercise its power of judicial review under 226. So therefore, similarly, that principle will reversely apply here because a deputy commissioner who is head of the district without obtaining permission from the state government who has notified the Kalikopul District Hospital Memorial along with the office of the district medical officer, you try to shift this. So therefore, on the basis of this foundation itself, the interference is called for. My lord will kindly come to this particular page. This is the rules of, my lord is aware that 166, this impugn order, my lord will find at page 25, my lord. Yes. My lord, just take out page 25. And my lord, hiring, my lord, is a central point for all the circle headquarters of that Anjar district. And Hawaii is a bit far, another 60 kilometers away from there. So for administrative, therefore, any decision that authority takes must have a reasonable must be reasonable and on the doctrine of proportionality, my lord. You cannot take a decision in this manner, my lord. My lord will kindly have this page of my rules of business allocation, my lord, 220, my lord. I am the citizen of that area, my lord. Common users who are the beneficiary of that district hospital. My lord will have this page 220 for a moment. 220 that I have not made up.
But I'm
No.
thinking, what I'm thinking loud
Yes,
is the fact that I've been a resident of Guwahati. My age is about 50, is about to reach 58. Plus minus few months I may forget. So let us say 58 years. I've never been required to go to the office of the medical officer. I've gone to the hospital, I've gone to nursing homes.
that is grace of
But
Lordship
to,
Savior
but to,
in the
no, no, but
Creator.
to attend the office of the district medical officer, I don't know. Did you have an experience ever? To attend the office of a district medical officer? You would be 40 now, look young. See this 40 years,
About
did you have an opportunity of going there?
nearing half century, my lord. Nearing half century.
Yeah, half century. Oh. Then we have been deceived by your appearance.
No,
But I don't think so, because
no,
this is
the
nobody-
rationality of my lord's question that has fallen. It is my duty to answer it also. my lord. Now, what happens is the requirement is that district hospital, my lord. The district hospital at Hylon. There was a cabinet decision wherein it was decided that the district medical officer office will also be situated there. Therefore, what I am contending, my lord, by
No such cabinet.
let me come. Let him finish.
no, therefore, my lord. Anyway, it happens sometimes. Anyway, my lord. Therefore, what I am contending, can by means of this impugn order issued by the deputy commissioner, can override the decision of a cabinet. Respectfully not.
That depends on where is the cabinet decision.
Cabinet decision is not there, my lord. We have tried, but I got one letter, my lord. Instruction, it is given to them also, but they have not produced it.
If I remember the rules of executive business, then and if my memory is serving me right, every cabinet decision taken is required to be notified by the appropriate governments.
It has to be notified in the Gazette.
Yes,
Then it comes into force, my lord.
yes.
Date of notification in the Gazette.
Therefore, the gazette is in public domain. If there is a
Correct.
cabinet decision,
Correct.
they would have been available in
Correct,
the public domain.
No, my lord, we tried. Even we filed the RTI, requesting them to provide a copy. They said cabinet document decision, being a policy decision, it comes under classified documents, so we are not.
No, you could have asked for a notification. You see, cabinet decision may discuss so many things.
My lord, we tried. Therefore, this letter has come, my lord.
Neither received any copy of cabinet decision on retaining DMO, nor received any instructions from the government.
That is the only letter that we got. That's also sent to
Because
them.
if there is none, we can't compel the government to produce it, because if there is any cabinet decision and not notified, you see, cabinet may discuss so many matters, very sensitive matters they may discuss. So that decision will not be available.
Not be available. That's
Only if it's notified. Then it comes, it is in a form of gazette, and then it is notified to the general public. And that is a decision which is permissible under the.
my lord, if my lord allow me 1 minute, I give an example, my lord. Suppose we have one hospital here, Tomorrow Institute of Health and Medical Science. Now, infrastructure has been created. Now, a particular name has to be given. Then what happens? The cabinet sits in terms of Article 164 of the Constitution, then takes a decision under Article 166. That's why, always there is a quarrel between the chief minister and the governor. where you cabinet, you take decision in my name and paper never comes to me for perusal. And you issues in my name. So, but that is the requirement under 166 clause 3 of the Constitution, my lord. That is what authentication by the under secretary to the secretary, whatever it is, my lord. So then what happens? The department, my lord. Firstly, suppose renaming has to be, naming has to be done. Then the concerned minister is requested by the chief minister, and minister concerned will direct the concerned secretary of the department to process in the file. Then they takes the decision, my lord. Then it comes to the cabinet, and then it sends. Once the cabinet has taken a decision, it is notified. Then there is a program, my lord.
Yes.
This is how the naming and renaming has to be done. For alteration also, my lord, the same route they have to follow, my lord. And my lord, the affidavit of the health department is very loud and clear. There is no infrastructure as such, my lord. No, therefore, my lord, can we have the affidavit of the health department? Respondent number 2. My lord, that at para 2, my lord, 3.1, at page 3, my lord. That is what the my lord will take some pain to read paragraph 3, 3.1 to 3.2, my lord. The answer is available. It is these reasons why the DMO has refused to shift the temporary office to Hava. These are the reasons, my lord. Or, my lord, alternatively, may I make a proposal, my lord? Remand the matter back to the appropriate authority for a decision. My lord. Correct, my lord. Correct, my lord. My lord, Uni had some query to me. Yes, these are the contention basically I am raising, my lord. And therefore, my lord, now a simple question, my lord, for determination of lease in this particular case is whether a delegatee officer can override the decision of the cabinet, my lord. And that is the only question. If that is the proposition, then, my lord, this order is liable to be interfered with. And, my lord, to support, to fortify my argument, my lord, paragraph 3, 3.1, paragraph 3, 3.1 to 3.2, my lord, of the affidavit in opposition filed by the respondent number 2 further fortifies my argument, my lord. Therefore, my lord, I was requesting their lords how to do. My lord will have this last page of my rules of business allocations, my lord. Okay, sorry, my lord, sorry.
Malad, here it's that the DC office, Malad. Yes, Malad. Itanagar and UPIA, the Papumpara as a whole here, we have a here at UPIA, Malad, district headquarters. Malad. Malad, it is hardly 300 meter, 200 to 300 meter just here. Yes, Malad, from here.
My lord, Papumpare, there are two. My lord,
Malad, offices, Malad. Malad, there's lots of Malad that exactly that I cannot say, but it is enough infrastructures there, Malad, here in Nahat. Yes, Malad. Okay. Malad, only I just from just my side, Malad, just clarifying, Malad. Malad, regarding the DMO, Malad, 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 no. Malad, that much bigger is not required, Malad. Only okay. It is at present, Malad. 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 Malad, I'll just try to get Malad. Malad, I'll try to get telephonic, just a minute.
No. So, my lord, my proposition was already said, my lord. So therefore, this court is requested to exercise its power of judicial review, my lord. In view of the fact that a subordinate officer is trying to overturn the decision of the cabinet, my lord. My lord, my favorite judgment, my lord knows. Marwari versus Medician, my lord, 1863, one crunch, page 137. How Lord Marshall, then Chief Justice of the US Supreme Court, propounded the power, my lord. So therefore, that paragraph 15, in one of the case I have relied before Lordship Surana in principal bench, my lord. Although I got it, I did not got the relief, but then it was so satisfying arguing that case, my lord, almost for 1.5 hours. My lord, that is basically now, my lord, the power of judicial review, my lord, has been recognized as the basic structure of the constitution, my lord. And that particular power, my lord, will find L. Chandra Kumar versus Union of India, my lord, paragraph 1997, 3 SSC 261, my lord.
My lord, I got confirmed, my lord. I've just talked telephonically. My lord, presently, DMO office UPIA is about 40 by 70. It's come to 280 square feet, my lord. 2,800 80 square feet. And in addition to that, when the adjacent, there's also under the DMO only, their DRCHO office, there's 500 square meter, where there's the storage is there. Mala, this is there in DRCHO.
In-
500 square meter and was 2,800 square feet. DMO office.
In our case, my lord, just correct, my lord. The sense has to be understood in a proper perspective. So therefore, my lord, if there is a infraction, therefore, my lord, if there is an infractions of the right by action of the administrations, therefore this honorable court in exercise of its power under 226 in the form of judicial review can always interfere with the decision of the administrative authority. My lord, that yes. My lord, just I was giving that Madison versus Manavari judgment, 1863, one crunch, my lord, page 137, my lord. I remember paragraph 15, my lord, kindly see that. And then, my lord, in the letter judgment, their lordships are aware, but still I'm trying to refresh ourselves, my lord. That, my lord, is aware that L. Chandra Kumar judgment, 1977, 3 SCC, page 281, my lord. That these are all in my mind, my lord. Because in, my lord, that 1982, Maneka Gandhi judgment.
Chandra, L. Chandra should 1970.
No, L. Chandra Kumar, my lord.
Chandra,
1997, my lord.
19.
Yeah, that's, we know,
Not 77, my lord.
that we
3
are
years.
acquainted.
That L. Chandra Kumar judgment, my lord, recognize
Mr. Tarak,
judicial review as a part of
Mr. Tarak,
the base.
we'll come to all those things.
Yes,
Provided you can show to us that there was a cabinet decision to this.
Well,
Neither of the parties have brought that on.
no, my lord, therefore, my lord, only that particular letter we have.
That is neither here nor there.
Neither here, neither there.
So we'll have to go by the materials available on record.
Correct.
That much.
No, my lord, that I'm trying to assist, my lord, in certain way where my lord will have a look on this aspect of the case also, my lord. Now, my lord, why this decision is bad? Because it has no nexus at all, my lord. You are trying to shift the office of the DMO to a marketplace. Kindly see the report, my lord. The order itself speaks. They wanted the entire office to be shifted in a marketplace. Marketplace and the government office establishment locations are two different things, my lord. Therefore, my lord, there is no nexus of rationality, my lord. When I make argument on this, my lord, on the rational nexus, my lord is aware, any decision taken by the authorities must be reasoned, well informed, impregnated with rational reasons, my lord, and nexus. My lord, in that such a situation, my lord, that Anwar Ali Sarkar versus Bengal judgment, my lord, there's 1952 judgment, my lord. These things will come, my lord. This is absolutely unfair, my lord. Now, my lord, the old principle, that is arbitrariness is always opposite to the equality, my lord. Therefore, in the absence of rationality in the decision-making process, and here, my lord, will recall that E.P. Royappa judgment, my lord. Equality and arbitrariness are the sworn enemy, my lord. So, my lord, that 1978 Maneka Gandhi was overruled in IR Koale of 1999, certain portions of the decisions, my lord. So therefore, my lord, all the pleadings are on record, my lord. My lord will take a call and pass appropriate order, my lord. Grateful, my lord.
This, you referred to that Madison, what is that citation? Please give it to us.
1863, my lord. one crunch.
1863 or 1883?
No, 1863, my lord. I remember 1863, one crunch, page 137, my lord.
What is the name?
Marbury versus Madison, my lord.
Marbury.
Marbury, M-A-R-B-U-R.
M-A-R-B-U-R-Y.
B-U-R-Y, Marbury versus Madison. Yes. My lord, I forgot to bring that order. My lord, there was a cancellation of NGO.
Marbury versus Madison.
Yes, yes. my lord.
Okay, okay.
Well, this was quoted in one of Lordship's judgment that I was doing a case of Jorad, my lord, that some Mandir committee, management of the Mandir committee.
Okay, on power of judicial review.
Yes, yes, my lord.
Okay, we get it.
So, my lord, just I remember all this judgment because these are in my heart and mind, my lord. Just I keep reading this for my own interest, my lord. Just to know, try to know the nuts and bolts of the law, my lord. If I can correct any of these basic principles of the law, my lord.
That's good.
I try my best in this manner only, my lord.
Yes, Mr. Ram.
Lordship, when Anjo district was created in 2004, the district headquarters was not right. Therefore, in order to run the district, all arrangements were made temporarily, Lordship. So once Anjo was declared as the district headquarters of Hawaii was declared as the district headquarters of Anjo, all infrastructure were created there, and thereafter, Lordship will even see not only the DMO office, many offices were there in the Haulian, all have shifted, Lordship. Only the petitioner only they have rejected, saying that DMO office is required. In fact, the DMO office is always the district hospital is always run by a superintendent, not the DMO.
Please come again. District hospital.
The hospital, the head of the hospital is the superintendent of.
Yes.
District medical.
And
Page 4 of the. Not page 4.
Not by DMO also.
Yes.
So DMO.
Page 4, last paragraph here.
Okay, we have got it.
So DC being the district health society, the presence of DMO is always necessary whenever regarding the matter of health issues come. Therefore, necessity of DMO with DC is always necessary.
My lord, in my respectful submission, my lord, the like shifting of office and especially district head office, my lord, it may not be the subject matter for judicial review, my lord. The reason being, this is administrative matter, administrative arrangement, my lord. We cannot, my lord, look into the validity of the decision of the district administration, my lord. Although we have whatever difficulties we have, that is administrative region that we have to resolve it out, but this is not the way it has to be resorted through the judicial review, madam. Therefore, my respectful submission, madam, the writ petition is not maintainable. Although we have expressed a certain difficulty, that is to be resolved out by administrative way. Now, there ultimately, so far, when district is created, madam, every district head office has to be there in headquarters, madam. This is exactly what's doing, madam. Of course, the shifting there may be some it may solo or some the shifted fast wherever the infrastructure ready. But so far, DMO of concern is concerned. Shifting, we are not objecting because it cannot be. It's part of policy decision. And by way of enactment, it was already created in the way back in the year 2004, my lord. It was the district headquarters. Now we are bound to all the district head offices bound to shift there, my lord. Only the delay problem is that due to certain infrastructure problem, and that's part we are facing, my lord. So in this aspect, Malab, we cannot say that if it is interfere with this impugn order, ultimately it may have a cascading effect because. So temporary arrangement, that is whatever we are with them, but how long we can run. But one day it has to be shifted, Malab. We are also ready that once it is infrastructure ready, now the mini secretariat is being constructed now. The once it is over, we are also bound to shift, Malab. That is where we are also looking after, Malab. We're waiting for that. It is almost, the halfway is almost constructed, Malab. Mini secretariat at Hawaii, for where all the district head office will be situated in the one secretariat. That is being constructed. So regarding, Malab, this matter, it cannot be purview of judicial review, Malab. That's yes. Shifting of office, district headquarters. Para 5, 2002, 10 SSC 226. Para 5, this we cannot decide.
And please come again that present area square feet, what was that?
My lord, present square feet at the here, Papumpara district DMO office is approximately 2,800 square feet. That is 40 by 70 feet, my lord. Come to 2,800 square feet in the DMO office, my lord.
48
Then-
into,
My lord,
48 into
48 into 70 feet,
70
my lord.
feet.
Feet, my lord. It comes to 2,800 square feet. And adjacent office is DRCHO, my lord. It is 500 square meter.
Square meter.
Yes, ma'am.
That will be how much?
My lord, at division bench, on the earliest occasion, my lord,
Just now.
Well, it comes 5,381 square.
5,381.96 square feet.
Correct.
my lord, DRCHO office is 500 square meter, my lord. 500.
No, in meters, feet, in feet, it will be
Yeah, feet, my lord, that
5,382.
will be.
Okay.
Another para judgment hearing, right? Another para judgment.
Well, one more decision, Malad, of our hearts on material.
Milord, I just have a 1 minute liberty as a rejoinder, Milord. Milord, kindly come to paragraph 5 of that particular judgment. I am aware of this judgment by Sapre, His Lordship Sapre, and Lordship Buya's judgment. Yes. Paragraph 5, Milord, kindly come. Milord, the fact in this case was the construction of a recreation hall. But it is, our is not the construction of a recreation hall. It is shifting of an office, my lord. My lord, in paragraph 5, my lord, what it says, in the light of authoritative pronouncement of the Supreme Court, we find absolutely no merit in this. That is Kanda Para, my lord, judgment, which my brother has placed earlier. We find absolutely no merit in this writ petition because it is not for the court to decide as to where one should construct a building in the city. It is essentially for the state to decide whether it should at a place at A place or B place. Once they choose the venue, such decision cannot stand for judicial scrutiny or in our extraordinary jurisdiction under Article 2 to 6 of the Constitution, unless it has prima facie case based on peculiar undisputed fact. Now, my lord, see, the Standing Council of the Health Departments blows hot and calls. Kindly refer to their paragraph 3.
Malad,
Paragraph 3.1 and 3.3, my lord. You cannot blow hot and cold. No, you cannot blow hot and cold. You have come in the form of affidavit. You have taken a categorical statement. How come you raise this issue? You are stopped from raising this. And one cannot make submission beyond the instructions, beyond the affidavit as a government counsel, my lord, except or otherwise on the question of law, my lord. No, respectfully not, my lord. With greatest respect, without malice to you and prejudice to your right. As an elder, I am making a request to you. Most of the time, my lord, we witness this. I am aware of this judgment. I am aware of this judgment, my lord, because no, there cannot be rejoinder after rejoinder. You must also know this.
my lord permits me just one clarification, my lord, just with regard to my affidavit only. Madam, we have not controverted my affidavit, madam. Madam, right, madam, that is what, madam. My submission is the madam.
Anyway.
I may be allowed to withdraw our names from the Wakalatnama. As my lord,
We can't permit that because of the fact that if you look at rules 64 to 68 of the Guwahati High Court rules, chapter 5, you will know about it. It has to be done in a manner prescribed.
My lord, as desired by the petitioner, and moreover, the petitioner wants to pursue the case in petitioner in person. Moreover, he is an advocate.
You see the High Court rules. There's a manner in which that can be done. So therefore, we can't permit an oral prayer. So you may choose not to appear. That is your choice, but we can't expend your appearance by a judicial order. Correct? You may choose not to appear. That is your, if you have been instructed not to appear, you may not appear.
Yes,
But
ma'am.
we can't strike out your name.
As such, my lord, this may be adjourned.
No. If
Okay.
you're not no longer there, if you're instructed not to be there, you are not there.
Yes.
You can't adjourn it on your prayer if you are not instructed.
My lord, I'm on the maintainability. Lordship will just see the prayer. My lord, unfortunately, PIL of this nature are being entertained. Just have a look at the prayer, my lord. Prayer number 1, allow the present petition and direct. Sorry.
Yes.
The prayer, my lord. PIL, page 32. Allow the present petition and direct respondent number 9 to register a report under section 154 of the Code of Criminal Procedure and investigate the case. Monitor the investigation of the case. Direct a judicial inquiry into complaint of the petitioner. So register an FIR 154, then judicial inquiry also. Then monitor the investigation, continuing mandamus. Pass any other or further orders as this honorable court may deem fit and proper. So basically, my lord, all kind of allegations have been made. And what petitioner is seeking is registration of an FIR under 154. That is the sum and substance of the PIL. Now, my lord, very simple. I'll just show there was an investigation into the complaint of the petitioner. Full-fledged inquiry was there. Nothing was found. Inquiry was closed. All the details are available here, my lord. Affidavit by respondent 10. Lordship will see page 7. Page 7 and page 8. Page 7, paragraph C. I'll just read this paragraph.
Who is respondent 7?
My lord, respondent note. Affidavit in opposition by respondent 10.
or 10?
Respondent
Who is
10, my
10?
lord, is the official respondent. Sorry, I'm sorry. No. It's a private party, but private party, my lord, has given the official documents. Respondent 10. I represent respondent 10 and respondent 11. I am for respondent 10. Miss Nirvana Enterprises, such and such.
Can we draw any presumption because respondent number 10 is bringing official documents and the official respondent?
No, my lord, these are the documents taken from the state's affidavit. The state's affidavit is also there. My lord, these are the documents of the state.
Oh, then it's okay.
These are the documents of the state. The state has filed the similar documents.
Then it's okay. We were just asking you, thinking
Yes.
aloud, whether what
My
presumption
lord,
should we take?
the paragraph C of internal page 7 of the affidavit in opposition relies totally upon the documents of the state government, which will be buttressed and supported by the affidavit of the state government. I'm referring to para 7 simply because the entire picture will be clear to your lordship.
Yes.
Internal page 7, I read para 7, that the petitioner in the writ petition is prayed for a direction to the Commissioner and Deputy Secretary Special Investigation Cell, Government of Arunachal Pradesh, to register a case under section 154 of the Code of Criminal Procedure 1973 and thereafter initiate investigation in the matter. It is pertinent to state that the writ petitioner had filed a complaint before the Superintendent of Police, a Special Investigation Cell on 9/3/22, alleging several irregularities in the work quote, system strengthening of 33 kV, 11 kV LT line and distribution system in West Kameng, Tawang and Namsai district under DDU-GJY scheme. It has been alleged by the writ petitioner that no action has been taken on his complaint. The answering respondent humbly begs to state that firstly, it is totally incorrect that no action was taken upon the complaint filed by the petitioner before the SIC, and secondly, even assuming no action was taken, the proper course of action in such and such. Then comes the next page, where reliance has been placed upon documents. With regard to the allegation that no action has been taken by the SIC, the answering respondent humbly begs to state that such a stand of the writ petitioner is totally negated by the additional affidavit filed by the respondent 9, that is the Commissioner and Secretary, SIC, on 13/9/22. A perusal of the said additional affidavit goes to show that upon receipt of the written complaint submitted by the petitioner, the SIC took cognizance of the matter and proceeded to investigate the same. To ascertain the veracity of the allegations made by the petitioner, the SIC wide letter number Vigilance such and such dated 12/4/22, that is page 140 of this affidavit, requested the Commissioner Power Government of Arunachal Pradesh to furnish comments on the complaints made by the petitioner. Pursuant thereto, a detailed inquiry was conducted by the authorities and a report was submitted by the Chief Engineer, Power Western Electrical Zone on 27/6/22. Refuting each of the allegations, the said report was forwarded to the Deputy Secretary Vigilance. Upon receiving the report, the Deputy Secretary Vigilance once again, while letter dated 3rd of August 22, requested the authorities in the Department of Power to submit specific replies with regard to a few of the allegations. In response thereto, the Chief Engineer Power Western Electrical Zone, wide letter dated 3/8/22, submitted another detailed reply to the specific allegations mentioned by the Deputy Secretary Vigilance. The reply report, along with supporting documents submitted by the Department of Power, were examined by the SIC, and upon being satisfied, the Commissioner, wide letter dated 8/8/22, accepted the report submitted by the department and closed the matter. My lord, that final report, my lord, will find at page 157. Commissioner Vigilance, page 157.
Yes. Yes.
That is 8th of August 22, Commissioner
8th of
Vigilance, Government of AP, to the Secretary Power, page 157 of the affidavit of Respondent 10. Matter related to complaint, the subject. Matter related to complaint on alleged irregularities, misappropriation of public fund, accepting fake and fabricated bank guarantees such and such, reference such and such. Sir, in reference to the aforesaid subject, it is to inform that based on the complaint filed by Sri Kaku Potom, which was endorsed from SIC Vigilance referred above, the various reports and clarifications submitted from Department of Power, along with various annexures, have been perused by the competent authority. It is further to appraise that the point-wise allegations of the complainant and the report explanations, clarifications with supporting documents have been perused by the competent authority. The competent authority has approved for acceptance of the report submitted by department and closed the matter. So this is the closure. The report is also annexed here. The report, my lord, is page 154. My lord may see. There are two big reports. This is by Chief Engineer Power, page 154 to 156. It is preceded by another report, which begins from page 148. That is, my lord, the report of the report of Chief Engineer, Power Western Electrical Zone, from page 148. 148 to 152. Detailed report on various facets. Then submission on point-wise comment, page 153, and again the point-wise. More clarifications. So those clarifications were given in page 154. Now, my lord, the issue is, state has done all this. State is satisfied. There is nothing in it. If the petitioner is still not satisfied, file a criminal complaint. This is what Supreme Court says. Go there with evidence before a court of competent jurisdiction. The power under Article 226, my lord, is not for this purpose. My lord will not be ascertaining the facts on the basis of affidavits, who's right and who's wrong. There are judgments, my lord, I can cite. Go with criminal complaint.
It appears you have a lot of faith on us.
So that's why, for this is the exercise, all kinds of affidavits, huge, voluminous. The precious time of the lordship is being wasted in such an exercise. One judgment on site.
You don't
No,
read, you don't read matters appearing in public domain. Recently, somebody said that judges don't work.
My lord, the
And-
comments of this nature.
And when we want to
My
read
lord,
this-
I am familiar. My lord, I am familiar. The gentleman is brilliant in his own right. He is a scholar in his own right, but he has absolutely no understanding about the manner in which the judiciary functions. Normally, sir, comments are made by only those who are not the lawyers.
No.
The lordship has to read the brief. We understand these things. I know, my lord, we are all aware of the remark. These are made by, my lord, of course, in their own right, they are very intelligent people. They are doing a very good work. But the problem is, my lord, they are not familiar with the functioning of the judiciary. That is why the whole trouble. The gentleman. The whole difficulty is the file is not taken. And
It's okay, come on. It may be because of the weather, Mr.
I'm sorry, the court has dealt with this, my lord, para 6 and 7. I'm Subramaniam. I'm sorry, I've got only one copy. Para 6 and 7, lordship will have a look.
Citation?
I've given the. No, that's another, that's on a different aspect. It is on.
No decision of
Yes.
contingent judgment.
And so, that are, all right. And that's the settled law.
Yes.
You are not satisfied, if I am not registered, file a criminal complaint. Very well. That was the purpose, my lord, because other references have been given over there. So that is the purpose, because it contains other references. And there are relevant quotes from those very judgments. That is why I brought that. That is the purpose. Because, my lord, in a PIL jurisdiction, lordship will not be exercising, my lord, the administrative powers. There is a limit to which, my lord, judiciary can go and interfere in certain matters.
I have responded, my lord, in my affidavit, respondent number 6. Yes. Respondent number 6 affidavit, I have responded. I am appearing for respondent number 6 as executive engineer. The whole PIL is, my lord, under a garb of PIL directed against the respondent number 6. My lord, 142 crores was not spent, my lord, from an earlier scheme. That is how, my lord, there was an urgency in, my lord. There was an urgency in implementing this. So all the officials concerned were camping in Itanagar. We have responded like this. Yes, at paragraph 13, my lord, of respondent number 6. Paragraph 13, madam. In fact, my lord, if I may just point out, except for bald and vague allegations, sweeping allegations, my lord. Yes, I've answered, ma'am. Your lordships may kind. Who declared for a petitioner, my lord.
Lordship B come duck. Yes, Lordship. B come duck.
Learned counsel appearing on behalf of the petitioner had submitted at the outset that that he has been instructed not to appear for the petitioner, as the petitioner would like to present his case in person. It is submitted that the brief has also been taken away, and accordingly he prays for an adjournment. Next paragraph. We take note of the said submission. However, on the ground that the Full stop. Therefore, on the ground that the learned counsel for the petitioner do not have a mandate to appear, comma, the court is inclined to observe that the petitioner remains unrepresented when the matter was called up for hearing. Next paragraph. We have heard in serial order who is for 1, 2. 1 and 2. We write in serial order your appearance.
But I appear for respondent 10 and
No, no.
11.
We are going by serial order. One is Chief Secretary, Mr.
Yes, sir. I will be appearing for 1 to 5,
Huh.
7,
Huh.
8 and 9.
Please write in serial order.
Yes, sir.
Huh. So that it's kept in order. Hudson, so. Next paragraph.
1 to 5. 9 or 6.
This PIL, this PIL has been presented under Article 226 of the Constitution of India. Full stop. The petitioner the petitioner has stated that he is a practicing advocate and a social activist, and therefore alleging rampant corruption and serious irregularities in actions taken by the public functionaries, which allegedly resulted in serious monetary loss to the exchequer, comma, this PIL has been filed. Next paragraph.
10 and 11.
In brief, comma, the case of the petitioner is that the pursuant to all codal formalities, comma, the respondents in the power department comma, through the executive engineer within bracket E, bracket closed, Bomdila division had issued a notice inviting tender number capital BED oblique DD oblique NIT oblique 09 oblique 2019 -20 oblique 1258 -66 dated 21/12/2019 in connection with the work of inverted commas system strengthening of 33 kV, comma, LT and distribution system in West Kameng, comma, Tawang and Namsai district under capital DDUGYJ in Arunachal Pradesh, inverted comma closed. Full stop. The petitioner alleges that the entire the manner in which the detailed project report was prepared, comma, its approval and the floating of the NIT to the execution of works was all done in complete violation of the CPWD manual and the General Financial Rules, comma, 2017, without adhering to the laid down norms, comma, rules standard operating procedures, etc. It is further alleged that there was rampant corruption and nepotism in awarding of the works in pick and choose basis, thus creating an impression that the floating of the tender was a mere farce. It is also alleged that the approval and authorization for initiating the NIT was made on 17/12/2019, and accordingly, it is projected that it was physically impossible for the file to travel to from the head office in Itanagar to Bomdila Electrical Subdivision on the same day. And accordingly, it is the case of the petitioner that the entire action of the respondent authorities in connection with the said NIT be inquired by lodging of an FIR. Next para. The learned senior counsel as well as the learned counsel for the appearing parties, respondent parties, have vehemently opposed the nature of prayer made in the writ petition. Full stop. It has been submitted at the bar that that in the affidavit in opposition filed by the for state who has filed
Filed by the state respondents as
No,
well as
which
by
is-
the
no,
private.
no, number.
1, 2, 5, 7 and 8.
1, 2, 5, 7 and 8,
And the additional affidavit by
Yes.
respondent number 9.
as well as additional affidavit filed by respondent number 9, as well as affidavit in opposition filed by respondent number
Respondent number 6.
6.
Bomdila.
6 and affidavit in opposition filed by respondent
Private
number 10.
parties, 10 and 11, private
10 and
parties. The contractors.
The said respondents have produced the inquiry report relating to investigation and inquiry made by various authorities. Just give us the names who has made the inquiry. Just write it down, Mr. Tiwari, and just give it to us in a piece of paper.
That's better.
Huh.
Do it. Huh?
One is the chief engineer Western Zone.
No, inquiry is by SIC, reports were received from. Like that.
No.
The inquiry,
But if there is any inquiry by the department, please refer to that inquiry.
by
If there is an inquiry by the SIT, please refer to that also. We incorporated in the order.
the inquiry report, one is by the
Just
chief
write it
engineer
down.
Power, Western.
No, just write it down because we need the date also.
Yes.
Inquiry report dated so and so. Just note it down and give it to us. We're trying to save some time on that account. First off, in this regard, reference is made to the following inquiry reports. Give a gap. Next paragraph. There are two reports. It is. Next, but the Learned Counsel appearing for respondent number 6 has specifically submitted that in response to the allegations made in paragraph 6 of the PIL, a specific stand has been taken that as the value of the approved works was of a
Additional report.
handsome amount, all the requisite, all the concerned officials were at Itanagar, were camping at Itanagar, and therefore the insofar as the departmental authorities are concerned, every work related to the approval of the DPR, approval of the project, and the approval of the tenders were all done in a transparent manner in the office of the Power Department. And all the officers, and so it is submitted that all the concerned officers had worked in tandem because the project was for strengthening the power distribution system in the remote areas of the state of Arunachal Pradesh.
And the entire process was to be initiated before 26/12/29.
And it is further submitted, there was some urgency in the matter as the tendering process was required to be issued within a time-bound period of
26/12/2019.
12/2020.
2019. 26/12/2019.
Or the work was to be completed.
No, my lord, the NIT was to be issued before 26/12. It was a demand by the REC.
29/12.
26/12/2019.
2019. Oh, okay. 2019. Okay. So accordingly, it is submitted that there cannot be a presumption of any procedural lapse in the mere fact of signature of the approval being made on, what is the date? Six. I put it on 17/12/2019. Next one. We have examined the inquiry reports referred to herein before. It is not for the court to embark upon a judicial review of the contents of the inquiry report to ascertain whether the inquiry was done in an appropriate manner and whether the finding is correct or incorrect. It was suffice to mention that the concerned authorities who had received the inquiry report had not found any discrepancy or irregularity or illegality in the preparation of the detailed project report, its administrative approval, as well as various steps taken for the issuance of NIT. There is next paragraph. In this repetition, it has not been disclosed as to how the petitioner arrived at a presumption of existence of corruption or nepotism in the awarding of the works. Full stop. As the petitioner is alleging that the works were awarded on a pick and choose basis, comma, it was the duty cast upon the petitioner to produce before the court the the documents to show that that there was that the tendering process was an eyewash, and there was some sort of and to show that the selected bidder was hand in glove with the other bidders, and the entire tendering system was a farce. Stop. That impression is not cannot be gathered from the materials produced by the petitioner. Next part. In this writ petition, in this PIL, comma, the petitioner is seeking leave from this court. Yes. To no, to register the report under section 154, not leave, huh? Leave is not there. To direct the, who is respondent number 9?
Precisely.
SIT, okay. To direct the commissioner of the deputy secretary, comma, special investigation cell of a government of Arunachal Pradesh, within bracket, respondent number 9, to register a report under section 154 CRPC and to investigate the case with a further prayer to monitor the investigation of the case, as well as the petitioner has made a prayer to direct a judicial inquiry into the complaint of the petitioner. Full stop. In the context of the said prayer, and on the perusal of the inquiry reports referred to herein before, the court is constrained to hold that the materials placed before this court are insufficient for the court to issue any direction to the respondent number 9 to register an information in a cognizable case within the meaning of section 154 CRPC. Full stop. Next, in the absence of any prima facie satisfaction that a case worth inquiry to be done by the direction of the court is made out, comma, we do not see any reason to either issue a direction for lodging of a FIR, nor there is any requirement for the court to monitor investigation. Full stop. At this next, the learned senior counsel for the respondent number 10 and 11 has cited the case of M. Subramaniam and another SUBRAMANIAM and another versus S. full stop Janaki JANAKI and another, comma, within bracket 2020 bracket was 16 SCC 728. For the purpose of supporting his argument that the High Court would not ordinarily issue a direction for registration of an FIR with a direction to the police to investigate and file a final report. And to further project that if the High Court starts entertaining such writ petitions, then they will be flooded with such writ petitions. Full stop. It is submitted that they said authority is also on the point that if a complainant so desires, he may approach the magistrate concerned under section 156 within bracket 3 CRPC. And if he does so, the magistrate concerned would have jurisdiction to record his satisfaction and issue a direction for registration of the FIR. And the magistrate would also have the power to monitor such investigation. So we find that the said proposition propounded by the Supreme Court of India in the case of M. Subramaniam was also is also contained in the ratio of the judgment of Sakiri, SAKIRI, VASU versus State of Uttar Pradesh, within bracket 2008, bracket plus 2 SCC 409. Next paragraph. Before parting with the records, at this stage, we would also like to refer to the fact that none of the participating bidders or any intending tenderers had approached this court to challenge the tendering process by alleging that the manner in which tender was floated was not in accordance with law. Full stop. There's no material on record to show that the manner in which the tender was floated was aimed to favor any particular bidder, or that there was any clause in the tender which would have an effect of restrictive bidding by only few tenderers. Full stop. The copies of the considered opinion that the apart from the fact that the PL does not disclose any material based on which any presumption can be drawn that there was illegality in the tendering process. The court also finds that the petitioner has locus standi to visit this public interest litigation. Next one. Accordingly, the first line, इसके पहले, or that the tendering process was a farce, or that the tendering process was a farce. Accordingly, the according to this, accordingly, in view of the discussions above, this public interest litigation stands dismissed.
Okay.
Finally, beloved, I am relieved of this voluminous file. I was telling Mr. Saxena that there is no space in my chamber to keep this file. It's a huge brief.
You one will come.
No,
Saxena will keep it.
no, you are wrong. And I can demonstrate that even if this file is disposed of, this is a file you should deal with it daily. You see, if you deal with it daily as a matter of habit for 10 minutes a day, you will be ready for the world arm wrestling competition in the next year.
That's why I'm happy to leave the file here. Yeah, this makes sense.
DB continue होगा क्या?
वही पूछने की
Hasta sonar. Hello. ¿Por qué debe? बोलिए
I'm not a petitioner. Yeah, this book it to me.
Both sides are represented on the prayer made by Mr. S.K. Deori. Matter is adjourned today. List on. Give date tomorrow. 30. 520. Item 15. No, stated respondent is not making a prayer.
I said, Lordship, the state respondent seeks more time to file their counter affidavit.
No, they are not making a prayer. You can't make it for them.
My Lordship, we have received our instruction, but it's incomplete. So we need some more time.
No, some more is very vague. Plus, how much time? How many days? It's a 2022 matter.
2 weeks, my Lordship, we'll be filing.
2 weeks. Which respondent?
All the responses.
All the respondents. One. Both sides are represented. This being a repetition of the year 2022, one last chance is given to the state respondents to file a affidavit in opposition in the matter. List after 2 weeks.
Oblige. May I please, madam? My lord, I beg to mention item number 9, ma'am.
9.
Yes, madam.
Yes.
Well, I am for the respondent, ma'am.
Yes. Why do you need time?
My lord, we are newly implemented party, my lord. So some time may be given to file affidavit, ma'am.
Okay. Also represented on the prayer made by learned counsel for the newly implicated respondent. List after
3 weeks, my lord.
after 2 weeks so as to enable the
Lordship,
said
Lordship, I am
respondent
for
to
the
file
petitioner,
affidavit in
Lordship.
opposition in the matter. Yes.
Lordship, 2 weeks time have given, Lordship. Government already filed affidavit, Lordship.
Okay.
I'm for the petitioner, Lordship.
Okay. So you don't want the affidavit of the newly implicated respondent?
No, Lordship, I want, Lordship.
We are granting it. Why you are wasting the time? You do not hear us.
No problem.
Please don't waste the time.
Of course.
Don't push me to a corner. You see, I always like to smile and pass orders.
Lordship.
Don't push me to a corner where I retaliate.
I'm sorry, Lordship.
Correct?
Lordship.
I want you, I come from the bar, so I respect the members of the bar immensely. So please hear us. If you have not heard us, please repeat. I'll repeat it for 10 times. Please don't make any observation without hearing the order.
Lordship.
Correct?
Lordship.
Okay. File affidavit in opposition in the matter. Okay.
All right. May I, lordship, item number 11, matter may be listed after 4 weeks.
11. Yes, why you need an adjournment? Who are you? Petitioner or respondent?
Petitioner on behalf of Puttuboi.
Okay. So why you want an adjournment?
Yes, sir.
Why? Why you want?
He's urgent work. So he want.
Both sides are represented. On the ground that the council holding the brief is out of station, the matter stands adjourned today. List after 2 weeks,
3 weeks.
3 weeks. Okay.
Much obliged. Yeah, please, lordship. Lordship, I beg to mention item number 2, lordship. Here, lordship, this is a motion matter, lordship. Lordship, the leading counsel, Mr. T. Chamo, your lordship, he is having health issue, lordship. So this matter may be listed tomorrow, lordship.
On the prayer made by council for the petitioner, list on, make it tomorrow, 35. Okay.
Your lordship, may I mention item number 6? Because I did adjournment because I need to file rejoinder in this case.
Somebody also took an adjournment.
Item number 6.
6, okay. What says it represented? List after 2 weeks, so as to enable the petitioner to file a rejoinder affidavit in the matter.
Oblate.
Lordship, I'd like to mention item number 8.
8.
Yes, this matter may be taken up after 2 weeks. I have taken consent from the
You have
opposition.
taken consent? Okay, you are for petitioner?
Yes, I'm for petitioner.
Okay. What says the represented of the prayer made by learned counsel for the petitioner, list after
2 weeks, lordship.
2 weeks. Okay.
I know, lordship. May I, your lordship? Your lordship, I beg to mention item number 23 with 24 and 25. I'm for the respondent, your lordship. I have taken consent from the opposite party.
No, 23 is a criminal matter of 2018. You can't adjourn it like that.
Your lordship, there is a slightly mistake here, your lordship. Today, we have brought the wrong file here, actually. With the similar name of the party, we have another case also. But however, we have brought the wrong file. So matter may be adjourned for today and fixed after 2 weeks, your lordship.
What says the representative? The learned counsel for the appellant submits that he has got a wrong file for which he seeks an adjournment. Taking note of the fact that this petition has been listed on several occasions and it is a matter which is 6 years old. Therefore, adjournment is reluctantly allowed. Next, it is made clear that on the next date of listing, the matter would not be adjourned. List after 2 weeks on a date to be fixed by the office.
Obliged, sure.
May I mention item number 13, madam? The last occasion, my lord, consent has been given for the adjournment of the matter for 2 weeks. My lord, this has been, my lord, wrongly mentioned by the junior for fixing the matter today, my lord. So, my lord, I've taken the consent of the other party also, my
But
lord.
this was on a mention being made. Somebody made a mention, this is listed on mention.
For adjournment, my lord.
No, somebody made a mention and that is why this is listed.
No, my lord, and the last occasion matter was, when the matter was listed, my lord, the adjournment was taken, my lord. And the matter has been fixed today, my lord, wrongly, my lord. Whereas I was not present on the last occasion, my lord. So I've taken the consent of the other party, Mr. Tony Pratin, my lord. He is the counsel for the other party, my lord. And he has also left for the, my lord, the other work. So therefore, my lord, he requested me to fix the matter, apprise your lordship to fix the matters on my lord, the 4th June, my lord. Just for a week, my lord. On 4th June, my lord. Is considered by the other party.
Make it 5th. Also as a representative on the prayer made by the Iran counsel for the petitioner. Narration is adjourned today, just from 5/6/2020.
My lord.
Oh.
Deeply obliged.
Lordship, I'd like to mention item number 17. The office note shows that the notice has been returned unserved, so I will be given chance to take fresh steps within a week. On respondent number 4. Yes. Okay. In view of the office note, detecting that the notice on respondent number 4 has returned unserved, Mr. K. Saxena, counsel for the petitioner, pays to allow him to take fresh steps. So prayer is allowed. The petitioner shall take steps within 2 days for service of notice on the respondent number 4 by registered post with AB. So the notice is made returnable on after 4 weeks, the date. Returnable on so. Post of. So 25th is hearing day, 24 or 26th? 26, 6.
26 June.
Learned counsel for the petitioner is permitted to collect the postal receipt number from the registry and submit postal track report prior to the next date of listing. List on so and so. Obliged.
Yeah, Lordship, I beg to mention item number 27. Lordship, the matter may be listed after 3 weeks as the leading counsel is suffering from viral fever. Could not come today, Lordship. I have taken the consent.
Yes, both sides are represented. List after 2 weeks as paid for by learned counsel for the petitioner. Sorry, appellant.
Obliged.
My lordship, I beg to mention item number 10 for the petitioner. Your lordship, this matter may be released after 2 weeks. I've taken the consent from the other side, standing counsel power.
List after 2 weeks was paid for by legal counsel for the petitioner. Both is represented, huh?
Obliged.
Finally, Your Honor. I'd like to mention item number 29 and 30. These two matters have been listed for supplementary hearing, Your Honor. However, paper book has not yet been prepared in the case. So the registry may be directed to prepare the paper book, Your Honor.
It's not yet prepared.
Not yet prepared.
29, 30. The counsel for the appellant submits that the paper book is not yet prepared. So the registry shall examine and prepare the paper book. No, it's not already prepared. Next list of 4 weeks in the orders column, awaiting preparation of paper book.
Deeply obliged.
You say both sides are presented.
Next.
Item number 1.
May I please, my lord, PC, my lord.
Yes.
My lord, this is the 4th round of litigation for the petitioner for his promotion and the consequential benefits arising therefrom. Lordship, please have page 20 of the repetition for a moment. Page 20, when the litigation first started in the year 2011, my lord. Page 20, my lord, that was the writ petition of the year 2011, where my lord would find it page 25, where the directions given to the state respondents, page 25, my lord. Para 14. May I read, my lord?
But this, even the division bench had dismissed.
My lord, the division bench has allowed till date, my lord, this petition for this particular petitioner. The division bench has allowed all the cases, my lord, even the division bench has allowed, and most recently, my lord, even the cancellation of the certificate has been set aside by the honorable court. My lord, as the matter stands on today, the respondents have given me the promotion. If lordship should kindly have that particular order, which lordship should find at page 53. Page 53 of the repetition, my lord. On commendation of the DPC.
Just a moment.
My lord. The writ petition where the state was dismissed, my lord. Writ appeal.
Okay.
Writ appeal where the state was dismissed.
We issue a notice then.
My lord.
Okay. I wrongly rated that. I thought it was your appeal which was dismissed.
My lord. No, my lord. It was their appeal which was dismissed. And later on, there were orders by the single judge.
What has happened to the caste certificate?
My lord, that was set aside by the cancellation of the caste certificate was set aside by this honorable court. The judgment I have given. Thereafter, my lord, there have been no further proceedings.
Okay.
Lordships may like to have page 52, my
It's
lord.
okay, we take your word for it.
My lord. The cancellation has been set aside by this honorable court. But prior to that, my lord, even before the cancellation was set aside, I was given the promotions. I've not been given the benefits, and I suffer in my pension.
Well, Mr. R. Majumdar, and counsel for the petitioner. The case of the petitioner is that although he has been given notional promotion with effect from 24/7/2006, but he has been denied back wages at the appropriate scale, correct?
My lord, I've been denied back wages from 2014 because that is what this honorable court has stated. I would be entitled to back wages only from October 2014.
Okay, from October two thousand
But the
fourteen.
benefits of notional would flow from 2006.
Okay. Appropriate scale from October two thousand fourteen. Promotion to the post of agriculture development officer.
Yes.
He's not been was from October 2000, appropriate scale under 2014. And accordingly, this petition has been filed under Article 226 of the Constitution of India. If you notice, returnable on, give a fixed date after 4 weeks, returnable on so and so. You're appealing to the government.
Yes, Your Lordship. I'm appearing for 1 and 4.
She appears for the respondent number 1 and
1,
4.
4.
And
Your Lordship, I'm for respondent number 2 and 3 on behalf of El Parme.
Your name I forgot.
S. Siram.
Yes, Learned Council, appearing on behalf of Mr. El Parme, Council, standing council for respondent number 2 and 3. Accordingly, issuance of formal notice is dispensed with. Stop, however, power. Requisite extra copies of the writ petition be served on them within 2 days. Next paragraph. The pendency of the writ petition shall not be a bar for the respondent number 3 to carry out an exercise to determine as to whether the petitioner would be entitled to area salary at the appropriate scale of ADO, sorry, Agriculture Development Officer, with effect from the month of October 2014, and to release such benefit if the petitioner is found entitled to the same. Next paragraph. This on after 4 weeks, 27 6 2020. No, 27 is Thursday. No, don't give on Tuesday and Thursday. Make it Friday 28 6. 28 6.
I'm obliged.
Obliged.
I'm obliged.
This is the second writ petition which I had filed. Earlier, I had filed for the directions to the respondent authorities to initiate departmental proceedings for violation of Rule 21 of the CCS Conduct Rule.
Yes. CCS conduct rules.
This can be passed on.
We are issuing notice.
My lord, perhaps there is a wrong in the course title because that lady, that officer, has not been as a party, my lord. She is a necessary party, my lord, because if any other passes by this honorable court, that will adversely affect her, my lord. If you not see the course title, my lord.
Of that, I had that make her party, but it will not affect only the disciplinary proceedings will affect.
No.
Okay, I will amend that.
That will affect her, my lord. Any other
You're
part,
right,
yes, my lord, that will affect.
Because I will add her as a respondent. I will amend the course title.
Okay. On Mr. Harish Nabam, learned additional advocate general for the state, has submitted that although allegations have been made in this writ petition against a particular person, but the said person is not rated as a party respondent.
Yes, ma'am.
And therefore he raises a preliminary objection as to maintainability of the writ petition. Post rock. Next matter. On such a preliminary objection being raised from Mr. D.K. Deori, Mr. D.K. Deori, and counsel for the petitioner, prays for and is permitted to amend the writ petition.
Course title.
Amend the writ petition in an appropriate manner. List after?
After a week.
List after a week.
Can a date be fixed, Your Honor? If date is fixed, then can it be on
If you
fifth?
to amend it, then only it will come.
First you amend it.
Okay.
You amend it, you move the registry.
All right.
Yes.
This is a writ petition, I'm challenging the suspension order, which was issued on 8 December 2021. After that, it was not reviewed. Days.
Okay. Issue notice. Mr. D.K. Deori, counsel for the petitioner. The case of the petitioner is that he was suspended by an order dated 8/12/2021, which has not been reviewed till date. And according to the order of suspension has been challenged in this writ petition filed in the Article 226 of the Constitution of India. This one. Ms. T. Brahma, learned government advocate, accepts notice on behalf of respondent numbers 1 and
1.
And I'm for 3 format.
One and
Only one.
only one. Okay. 1, And Mr. T. Tagum standing counsel for the Elementary Education Department accepts notice on behalf of respondent numbers 2, 3, and 4.
My lord.
First of- Accordingly, issuance of formal notices dispensed with. First of, however, requested extra copies of the writ petition be served on them within 2 days. Next. In view of the nature of grievance raised in this writ petition, it is expected that the respondent number 2 shall ensure that an affidavit in opposition is filed at least 1 day prior to the next returnable date.
My lord.
Next, this one, give a date after 4 weeks. Same, huh? 20? 26/6/2024.
Number 7.
You see, we have become descendant to relief because of the inordinate delay. How can you explain the delay of so many years?
Sorry, my lord.
You say that.
Look, this is a matter, my lord, wherein the petitioner, he was initially appointed in the year 1981. Thereafter, my lord, there was an incident happened in the year 1992, wherein, my lord, he was arrested, a criminal proceeding was initiated. And thereafter, in the criminal case, he was granted acquittal because under section 84, that he became insane. Actually, the incident that had happened because of his insanity. And thereafter, he submitted a representation appeal. After acquittal, he submitted an appeal. And pursuant to that appeal, my lord, he was reinstated in service. Now, petitioner has retired from in the month of, my lord, August 2022. Now, he is before your lordships with regard to the period with effect from his dismissal and reinstatement, because he was dismissed from service without any inquiry. They have initiated departmental proceeding by issuing a charge sheet. They appointed the inquiry officer, but in the meantime, they abandoned the inquiry and.
No, you see, Mr.
I'm
Das, what has happened that you were reinstated sometime.
Sorry,
you were reinstated when?
I was reinstated in service by order dated 11/11/2019.
11/11/2019.
Yes.
Correct.
And
now you're challenging the
I'm challenging the order.
It is the same order you are challenging
Yes,
now.
to the extent, because I am agreed by the fact the entire period has been declared as UL, extraordinary leave, without any pay and allowances, without any increment. My lord, reinstatement has become only a formality, my lord, because after that in 2020 I retired from service. The entire period my increments.
So therefore, you see, when you were restored in service, that means you did not have that mental disability.
Sorry, my lord.
This mental disability which you claim you have, psychosis or something.
Yes.
That was apparently not there when you joined service, because you would not have restored back into police service.
In the year 1981, it was not.
1919. 1919 when you joined.
No, there was a fit medical certificate by the doctor saying that I am fit to resume duty,
So
but
therefore-
I should not be given.
No. That's the point, starting point.
Yes,
You were restored in police service because you were fit,
yes.
correct? So therefore, from 19 till you retire or till this date, you did not raise it. Now you filed this
No,
request
this
in
is
2022.
prior to my retirement. This was prior to my retirement. This writ petition was instituted prior to my retirement, my lord. It's not that after retirement I have approached.
Okay. Where is that? This impure order is page 68.
Yes, page 68, my lord. Annexure P6.
Okay, now what is your prayer in the petition?
My prayer is that I have challenged this order to the extent that period has been declared as UL, extraordinary relief, prayer number 1, instead of granting full pay and allowances. And I prayed for, my lord, refixation of pay, granting the requisite increments, my lord. That is my prayer. I'll just take your lordships the facts of the matter, my lord.
No, that is the only point involved.
Yes, my
Any
lord. So
authority-
far, FR 54, my lord, this situation is to be regulated by FR 54, my lord.
Fundamental FR. Maybe FRS.
And
First book. FRS, sir. नहीं
FR 1.
उसके नीचे होगा।
नहीं है मेरे पास FR.
Oh, yeah. Fundamental supplementary.
Perhaps that is the
Part
older one, I think. my
Part
lord.
1. Oh, part 1. FRS, sir.
My lord can have this. Yes. So my first submission is that that period could not have been declared as UL. Even assuming that period has been declared as UL to be correct, I could not have been denied increments for the said period, my lord. My increments ought to have been notional.
Given to you.
Sorry, my lord.
Consequential benefits are given to you.
No, my lord.
Yes.
No, they have fixed my pay. If your lordship will kindly see the impugn order.
No, but for the period, it may be counted for the purpose of pensionary benefit.
The period, yes, that period for consequential benefit, sorry, pensionary benefit, but the benefit of increment that cannot be denied to me.
Correct. I now get the point.
That is my point, my lord.
Yes. How do you counter this?
Your lordship, I have a request, your lordship, because the conducting counsel, she is additional senior government advocate, Ms. T. She's having a hearing in the court too, your lordship.
After some time.
Yes, your lordship.
Okay.
Fine.
Okay.
Okay.
Lordship, extremely sorry. I had to file the affidavit by today, but since we have received the legible document, so this matter may be fixed on Monday. Lordship.
Monday.
Monday or Tuesday. Lordship. We have received the legible document today itself only.
You received it?
Yeah, only for the document only we could not file. Lordship.
Okay. What has the represented? Mr. Government Advocate submitted that he has received instructions today and will be filing an affidavit in opposition by 3/6/2024. Correct?
Lordship, by Monday.
According to place this matter on 5/6/2024.
Item number 14.
May I please your lordship?
Yes.
Lordship, this is lordship, this is non-payment of pension, lordship, pensionary benefits, lordship.
Yes, who is for the respondent?
Lordship, state will be the respondent, lordship.
No affidavit filed.
Lordship, in fact, simple instruction was sought for, lordship, whether charge sheet in respect of case that has been registered against me, lordship, that charge sheet has been filed or not, that is sought instruction was to be sought, lordship. As per my instruction, lordship, no charge sheet has been filed, lordship, and no departmental inquiry is initiated, lordship. In fact, I was suspended, lordship. That too, lordship, it was revoked way back in the year 2016, lordship. Now I have superannuated in the year 2023, lordship. For 2-3 months, lordship. Lordship, the authority concerns, they are not processing my pensionary documents.
Yes, Mr. Tapin.
Lordship, in terms of the order passed by the state government, Lordship, where Lordship vigilance clearance certificate is required, Lordship. Since case is pending against the Lordship petitioner, so therefore that NOC was not granted by the vigilance department.
No, vigilance after his retirement, you could not have withheld that.
Lordship.
You see, does the vigilance has power to withhold that? Are they vested with the power to withhold it without disclosing any reason? Under the state laws, is there any law which says that the vigilance report can be withheld without disclosing reasons?
If Lordship see the page Lordship, see the page 29.
No, Mr. Tapin, after retirement, there must be some provision in the pension rules of the applicable for the government of Arunachal Pradesh, by which the governor of the state reserves the right to withhold a pension. Was that order passed? What is the provision where under the
Lordship, so far withholding of this pension, Lordship.
No, you are adopting the central pension rules.
Yes.
So in the central pension rules also, there will be some provision.
The section 69 also.
Yes.
The
have you
rule,
exercised
rule
that power?
69 is applicable in our state laws.
Has the governor exercised that power?
No, not.
Then your vigilance cannot withhold it. You have to raise it.
Lordship, to that effect, Lordship, judgments are there, Lordship. I have one judgment of this coordinate bench, Lordship. Jumbo Ratan versus State of AP 2018 1 GLT. Similar situated facts, Lordship. And then Honorable Court has directed, Lordship, to disperse the pension, Lordship. The exact issue, Lordship, has just now raised, Lordship. Similar issue was dealt in this case, Lordship. And very fortunate that, Lordship, on the respondent side, my learned brother, Lordship, Tapin sir was representing this case.
Okay, we have a copy of this.
Lordship.
You have to release the government will have to release his pension within a specified time.
Yeah, if Lordship see the page 29 Lordship, the order, this is the state government policy Lordship.
20?
Page 29 of my affidavit Lordship.
Your affidavit.
No. Lordship, this is in connection to the Lordship guidelines to issue the vigilance clearance for purpose of promotion and retirement of so and so others Lordship. If Lordship turn to page 30.
Now, do one thing.
Yes, sir.
If you we record that for the purpose of till you continue with this inquiry, till you do the inquiry against the petitioner. You see, the law is that he'll be deemed to be in service. So you pay his full pay and allowances. You restore him to service. Pay him his full pay and allowances. After retirement, you are trying to hold a disciplinary proceeding. After retirement, you are withholding a no objection. So therefore, he's in service.
So this proceeding was started Lordship when he was in service.
I understand.
No.
But please tell me if I am wrong. For the purpose of disciplinary inquiry, a person must be deemed to be in service.
Correct. Correct.
Correct. So we pass an order that he is deemed in service. Petitioner is deemed to be in service.
No, sir.
No, two things can't happen. You say that he is retired, and then you say we are continuing with the disciplinary proceedings. We want to do it against him.
Yeah, not the disciplinary proceedings, the criminal proceedings pending against him.
So what if your 69 is not invoked?
That part laws is there because executive orders is there of our state government laws.
Somebody is not challenged it, we will have quashed it.
Though this is not under challenge laws.
No, I understand. That's why we are refraining from quashing it. You would have quashed it immediately. Without rules, the vigilance comes and says that, okay, you take my objection. Why a rickshaw puller cannot issue a notification and say that, well, I am a rickshaw puller in the locality, or I am the auto driver in the locality. I know everyone what type of character, what man is. Therefore, I will also give a character certificate. No,
This
this
is
can't be
admitted lawsuit rule 69 has not been lawsuit applied.
We can't.
But the only thing is that lawsuit, we have our own lawsuit, executive order lawsuit.
It's okay. We ask the vigilance to give a recommendation that the petitioner would be in service till the government thinks it's fit to start a disciplinary proceeding. And then for that, from the date of his superannuation till the conclusion of disciplinary proceeding, you pay him his full salary. Don't pay pension. Yes, Mr. Jini, you don't want a
I
pension?
think here lawsuit is about
Lordship, I want the pension, Lordship. I have superannuated, Lordship. I need the pension, Lordship.
But you don't want salary. You don't want salary.
Lordship, he is not in a position to come back and work, Lordship. He is retired. Lordship.
No, you'll be under suspension. You don't have to work.
Lordship, revoke it. Suspension has been revoked. Lordship.
It was revoked in 2015.
16.
Because you see, you had to revoke, otherwise he would not have
No,
retired.
it was already revoked. He was serving lordship. His suspension was revoked long time back, and he was serving in the department.
Service.
And he was given salary lordship. It's not lordship. Salary was not given.
But Mr. T. Ginny,
J. Ginny, lordship.
J. Ginny, learned counsel for the petitioner, also heard Mr. S. Tapin, senior government advocate, appearing for all the respondents. Next, brother. The case of the petitioner, in brief, is that while he was serving as Daftari, Department of Art and Culture, Naharlagan, a criminal complaint was lodged against the petitioner, which was registered as Naharlagun PS case number 19 of 2012, alleging that the petitioner had prepared fake allotment orders and the signature of the director was forged. Full stop. The petitioner was thereafter placed under suspension by an order dated 10/2/2012 under under Rule 10 within bracket 1 of the Central Civil Services within bracket Classification and Appeal bracket closed rules, 1965. Most of the order of suspension of the petitioner was extended from time to time. In the meanwhile, the competent authority had also granted prosecution, sanction for prosecution by an order dated 6/3/2014. It is projected that the petitioner had participated in the inquiry conducted by the officers by the crime branch police station within bracket SIT. Full stop. Thereafter, the suspension of the petitioner was not extended and on representation submitted by the petitioner, by an order dated 29/8/2016, the suspension of the petitioner was revoked by the Director, Art and Culture, Government of Arunachal Pradesh. Full stop. While in service, the petitioner superannuated on 34 2023. Full stop. The next, the petitioner submitted all the requisite papers for processing his pension. Full stop. It is posited that although the petitioner had applied for grant of an no objection certificate from the Deputy Commissioner, Capital Complex, Itanagar, as well as to the Secretary, Department of Vigilance, Government of Arunachal Pradesh. An NOC oblique Vigilance Clearance Certificate. NOC oblique Vigilance Clearance Certificate. So and so. Comma. The Deputy Commissioner, Capital Complex, issued a no objection certificate dated 28/4/2023 to the petitioner, and the Undersecretary within bracket Vigilance, Government of Arunachal Pradesh, had also issued a Vigilance Clearance Certificate dated 25/5/2023 to the petitioner. Next one. However, the Undersecretary to the Government of Arunachal Pradesh, Vigilance Department, by another communication dated 16/6/2023, which is impugned in this writ petition, has cancelled the earlier Vigilance Clearance Certificate issued on 25/5/2023 on the ground that the same was issued inadvertently and that a prima facie case and a vigilance SIC within bracket BIG bracket close PS case number 8 of 2015 had been registered against the petitioner under section 120 capital B 468 471 34 IPC. Accordingly, by filing the petition, accordingly, representations filed by the petitioner have not addressed, not been addressed, comma. Present petition has been filed under Article 226 of the Constitution of India. Next one. Per contra, the learned senior government advocate by placing reliance on the affidavit in opposition filed by respondent numbers 4 and 5, has submitted that in view of the policy decision of the state, right, order number capital VIG dash 71 oblique 214 oblique 365 dated 25/2/2020, correct? Page 29.
page 29 is the type copy, Lordship. So page 27 is the original copy.
Guidelines has been issued by the Commissioner within bracket Vigilance, Department of Vigilance, Government of Assam, sorry, Arunachal Pradesh, which makes it mandatory for a vigilance clearance certificate for release of pension after retirement. First off, in the said context, the learned senior committee advocate has submitted that the said order dated 25 to 2020, being a policy decision, which is not under challenge, the petitioner is disentitled for release of his pensionary benefit without vigilance clearance certificate being issued in his favor. Next paragraph. It is further submitted that the petitioner is involved in a criminal prosecution under section 120 capital B. This is not under the bracket, 120 capital B, just public 468, public 471, public 34 IPC. Under SIC within bracket VIG, bracket post, PS case number 8 of 2015, which was earlier registered as Naharlagum PS case number 19 of 2012. Therefore, therefore the respondent authorities cannot process his pension papers for want of vigilance clearance certificate. Next problem. Anything more, Mr. Babin? No. Anything more? No. No. Next one. We'll just take a small break and come back. Next one. There's no document appended to the affidavit in opposition filed by respondent number 4 and respondent number 5 to demonstrate that The new order has been passed passed in the name of the governor of Arunachal Pradesh by any and obligor by any competent authority, reserving right of the government to withhold the pension of the petitioner. In the yes, which is the rule? The copy is not there.
Lordship is asking about what rules, Lordship.
Pardon me? No. Mr. Tapin. Mr. Tapin, this the government of India has come up with this Central Civil Service Pension Rules 2021. Now you want to exercise power under the 1972 pension rules, or you are applying 2021 pension rules? Because
this part, earlier also some amendment was done. So then the state government is not very much to take amendment. Regarding it was this unless I take instruction, whether this is automatically applicable.
no, that will apply because your government of Arunachal Pradesh has a standing order of applicability of the central laws. There is a standing order.
Yeah. If there is then it will automatically applicable and then this will apply.
No, because then here is difference.
Only they
No. Here there's a huge difference. We'll send this book to you.
about this 21.
I'll show it to you just a moment. We are sending this to you. See this. You see, this is the old rule. 69 I have shown. Here there is a provision for this withholding of part of pension and gratuity on account of a judicial proceedings. 69, please see that, 69, correct? 3 or 4 permits that, correct? Now, under the new rules, 2021 rules, that provision I am not finding. Please check out.
Lordship, it will be Rule 8, Lordship, new act.
Under the new act, it will be Rule 8.
Rule 8.
Is it same as 69?
Lordship,
Is it-
I haven't seen, Lordship, I haven't seen 69, but I have seen section Rule 8, Lordship. Power to withhold or withdraw pension, Lordship. I think it will be similar, Lordship.
Achha, okay. Okay. But you see, under the new, under this new rule, I think there is a direction that the gratuity cannot be withheld. Oh, sorry, gratuity could be withheld, but pension cannot be withheld. Correct?
Lordship, Lordship.
Even in 69 of the earlier 1972 rules, but it can't be, there can be an overlapping provision. So 69 has gone to 8.
So if right of president before we do the petition, it's provided under rule 1972 also. It's under rule 9 and 69. Here the same thing is also given in this 21 rules. So for section 9, rule 9 is used. But the same rule 69. That part also it has to be.
He says it's in rule 8 now.
No, this same is also provided under this all rules.
His person. Please send the new book also.
It is. Because in the rule 9 of the old, because I am the same power is there. When posted the rule 69, whether it's available in the 21 rules also, that is.
Therefore, there's no document available on record to show that the appropriate government had exercised the competent authority under the government of Arunachal Pradesh had exercised right under rule 9 of the Central Civil Services within bracket pension, bracket close rules, 1972, and public or under section 8 of the Central Civil Services within bracket pension, bracket was rules, 2021. Next matter. In any case, the petitioner had superannuated from his service on 30/4/2023, and there being no order of the competent authority passed under the Civil Services Central Civil Service within bracket pension bracket close rules, comma. What is of the constitutional opinion that it will not be open in this case for the responding authorities with disbursement of pension and gratuity to the petitioner merely by denying issuance of vigilance clearance certificate from the Vigilance Department in terms of order dated 25/2/2020. Full stop. In this regard, we find support from the view of in this regard, the view of this court is supported by the decision of the Supreme Court of India in the case of State of Jharkhand and others versus Jitendra Gitendra Kumar Srivastava Srivastava and another, comma, within bracket 2013 bracket close 12 SCC 210, as well as the decision of this court in the case of Jombo JOMBO Ratan RATN versus State of Arunachal Pradesh and others, comma, within bracket 2018 bracket close 6 GLR 257 equivalent to is mean column equivalent to 2018 within bracket 1 bracket close GLT 395. Next one. In this by the set time. The yeah, adopted the Central Civil Services in the bracket was rules 2021. Rule 87 thereof, comma, the Central Civil Services within bracket pension, bracket close rules, comma, 1972 had ceased to operate. Stop. Even under the repealed Central Civil Services within bracket pension, bracket close rules, comma, 1972, comma, there was a prohibition under clause C of rule 69 for withholding of gratuity to be no, there was a positive mandate. You strike out of that. There was a positive mandate for provisional pension to be authorized by the accounts officer during the till the conclusion of the departmental or judicial proceedings. And the gratuity could be withheld till the conclusion of the judicial departmental or judicial proceedings. But there's no record of any departmental proceedings or any charge sheet being initiated against the petitioner or any charge sheet being submitted in the vigilance, precisely within bracket vigilance, bracket close, ES case number 8 of 2015. Next one. The Learned Counsel for the petitioner has submitted that under the Central Civil Services within bracket pension, bracket close rules, 2021, the power to withhold or withdraw pension is contained in Rule 8 thereof. Under clause C of sub-rule 4 of Rule 8 of the said rules, it is provided that no gratuity shall be paid to a government servant till the conclusion of the departmental or judicial proceedings and issue of final orders thereon. First of how, if no judicial proceedings have been drawn up by submission of a charge sheet till date against the petitioner till date, court is of the considered opinion that the said clause C of sub-rule 4 of Rule 8 of the CCS within bracket pension, bracket close rules, 2021 would not empower the respondents to withhold even the gratuity which can otherwise be retained by the respondent authorities till conclusion of the judicial proceedings. Next paragraph. Next one. In light of the discussions above, the court is of the considered opinion that the respondent authorities would not have refused to sanction and release the pension due to the petitioner and pension and other pensionary benefits to the petitioner on the strength of the on account of non-issuance of vigilance clearance certificate by the Department of Vigilance, Government of Arunachal Pradesh, on the ground that the competent authorities have not reserved the right to withhold the pension payable to the petitioner And moreover, as nothing is produced before this court, before that a charge sheet has been submitted in connection with the hearing before referred SIC within bracket vigilance, VIG, case number, PS case number 8 of, is that 8 of, for all intents and purposes, there is no judicial proceedings pending as the petitioner. And such pendency cannot be presumed by the respondents. Full stop. This court in the case of Jumbo, JOMBO, Jumbo Ratan, RATN, in bracket Supra, had observed in the said order that the not like that, strike out, not like that. Next paragraph. In view of the discussions above, the petition stands allowed by directing the state respondents to process the payment of pensionary benefit and other entitlements due to the petitioner within a period of in an outer period of 4 months from the date of furnishing of a certified copy of this order before the director, Department of Art and Culture, Government of Arunachal Pradesh, Indian bracket respondent number 5. First stop. In the event the Department of Vigilance, Government of Arunachal Pradesh do not issue a vigilance clearance certificate within a period of within a period of 3 weeks from the date of furnishing of a certified copy of this order before the secretary within bracket vigilance bracket goes Government of Arunachal Pradesh within bracket respondent number 2, the competent respondent authorities shall process the pension papers of the petitioner without insisting on the requirement of such vigilance clearance certificate from the Vigilance Department, State of Arunachal Pradesh. Next paragraph. Under the circumstances, we refrain from imposing costs. So you'll be requiring to give 2 certified copies, one to the vigilance and one to the director.
All right. Much obliged.
None appears on call for the petitioner. The petitioner is unrepresented. The order sheet reveals that the petitioner had remained unrepresented when the matter was previously listed on 8/9/2023, 6/11/2023, and 1/4/2024. So hence, it appears that the petitioner is not interested to pursue this writ petition. Accordingly, the writ petition stands dismissed. Ms. P. Pangulan, Government Advocate, appears for respondent numbers 1, 2, and 3.
This lordship, this petitioner had to file a rejoinder. Actually, since 2 months, the petitioner is suffering a delay. Lordship.
I'm not getting you. Please repeat again.
Lordship, that we have to file a rejoinder, Your Honor. That
You want to file rejoinder.
Lordship, 2 weeks may be given, Lordship.
Okay. Both sides are represented. On the prayer made by the counsel for the petitioner, just after 2 weeks was to enable him to file rejoinder affidavit.
Obliged, Lordship.
Yes. Yes, once you have reinstated him, that period, whatever you do, but he would be entitled to his pay revision or not during that earlier period. That cannot be stopped. You see, if I am granted extraordinary leave, supposing I'm sick today, I seek extraordinary leave for say 1 year. Correct. Now, during that 1 year period, will I not be entitled to the pay revision if it occurs? No, that's okay. Whatever he did, he was the worst man on the earth. You could have executed him. You could have, for whatever wrong he has done, you could have hanged him. But the question is, whatever he has done, is there any law saying that you will not get a pay revision, entitled benefit of pay revision? No, you could have passed an order. You see, leniency was taken. But you could have passed an order that he will be now placed in service at the lowest rank. But that was not done. You restored him back to the competent authority, restored his service. For that period, if it is a simple case of dice non, he gets the benefit of pay revision at least. That can't be withheld. Para? Para 22. Yes. Can you do it? Are you convinced with what is stated? Are you convinced?
This witness was also never reported to the any of the officers.
No, it is the trial court who has held it, and your officer has accepted it. You did not constitute a medical board and say that this was a false plea taken. You restored him back to service. Now, can you stop the pay revision? If you have any authority, if you have any provision of law by which it is done, that is okay. It shows that. Take it up tomorrow then.
I'm leaving today.
So when you are next available here?
Lord, if I subject to me, Lord, what
No, you can join by video conferencing whenever you want.
tomorrow?
No, not tomorrow, whenever it's convenient to you.
I asked for consent.
So far,
It's fine. Please give it.
FR,
Before matters are very-
I understand, my Lord. So far, FR 54 is concerned, it is explicitly clear.
No, that's okay, but she
Yes.
wants some time to argue. You can join on video conferencing some other day.
My Lord, if my Lord permits me, Lord, if my friend can argue tomorrow, then I can join by VC, my Lord.
So
Tomorrow
whatever
also
is, if
not
it's join by today or tomorrow, doesn't matter.
You can give a fixed time.
Tomorrow also not possible.
You choose a date from your calendar. Mr. S.K. Das, counsel for the petitioner. So,
First week of you know, 13th of June, 13th or 14th of June.
13th or 14th of June.
I think we difficult. Possible. Any date, my Lord, convenient to my friend, my Lord. If required, I'll join through VC, my Lord.
19.
Okay. The, on the prayer made by the committed cake, the magistrate is adjourned today. Let's list on 19-6, 19.
6. Sorry for the inconvenience. I asked for the consent. It's not a consent.
19-6-2023 is 24. Next para. The learned counsel for the petitioner is granted permission to join the proceedings through video conferencing, if desired.
I hope, my Lord, it will not be part her, I think.
No,
Because,
because
yes,
this is an outlying bench matter.
yes, my
Required.
Lord. That's, I understand.
Number 1.
Big. Yes, so your service is not complete.
Yes, my lord, respondent need to file counter affidavit. Respondent need to file counter affidavit.
No, service on respondent number 5 is still not complete. Five and six,
5 and 6.
still not complete. Oh, 6 is returned. Okay. Okay. Learned counsel for the petitioner is present. As per notice note dated 8/4/2024. ID card in respect of respondent number 6 is returned back after service. None appears on call for the respondent number 6. Next paragraph. As per office note dated 28/5/2024, service report in respect of respondent number 5 is still awaited. Next paragraph. The steps was taken long back. The petitioner shall take fresh steps for service of notice on the respondent number 5 by registered post with AD. Take steps within 2 days. For service not by AD. Next, the learned counsel for the petitioner is permitted to collect the postal receipt number from the registry and submit postal track report prior to the next date of listing. Notice is made, give a fixed date. Notice is made after 6 weeks, 4 weeks, give a date. It's also list transfer is okay. 27th, 6. No, 27 is again Thursday. Don't give dates on those days. 26th. 26th. Okay, take steps.
Ma'am, since there was contradiction in the statements made in the synopsis and paragraph 6 of the lead petition, therefore, while order dated 21/5/2024, I was directed to make necessary corrections to the synopsis. Ma'am. Accordingly, I have filed this IA seeking leave to amend the synopsis. Ma'am.
Good. I remember. Okay.
Proposed amendment is at page number 7, paragraph 7.
Okay. By filing this interlocutory application, the applicant seeks to amend the synopsis. No objection to that. The government advocate does not object. This J. Gangwar and then government advocate in the matter. Next paragraph. Considering the nature of prayer made, prayer is allowed. Next paragraph. The learned counsel for the petitioner is permitted to make necessary correction in the cause title of the correction in the synopsis of the connected writ petition by hand under his signature, which shall be done before that section. Yeah, section writ petition section, and before the judicial section, and thereafter the matter will be listed. The judicial section, and thereafter the registry shall list the matter in the motion column. You do it by hand. You're permitting you to do by hand. 20, 21, in view of those in view of what passed away, the Learner Council for the petitioner is permitted to make necessary correction in the synopsis by hand under his signature before which shall be done before the judicial section. Huh? Judicial section. Judicial section. And thereafter the matter be listed in the motion column. Patients and consecution orders will be passed in the connected equation.
Yes, Lordship, that we have taken a step upon the private respondent, Lordship.
Pardon me?
Private respondent, Lordship. We have taken a step.
Is awaited. The registration, the petitioner and the state respondents are represented. Next, the registry shall place the postal receipt number in the office note so as to, and the date of posting in the office note so as to enable the court to pass appropriate orders as regards service of notice on respondent number 5. List on. Make it next Wednesday. Five 6/2024.
That's it. All right, please.
Item number 26.
May I, Your Lordship? Your Lordship, this case is fixed for hearing today, Your Lordship, within LCR. However, the leading counsel for this case, he was present today this morning, but due to some urgency, he had to go to Zero, Your Lordship, for personal difficulties. So he has already left court premises.
Okay.
So matter may be adjourned for today and fixed after 2 weeks, Your Lordship.
Okay. On the ground that the Learner Counsel for the appellant have to leave the court for him. Matters prayer for adjournment is made. Most of the prayer is allowed. This is the matter after 2 weeks.
2 weeks, Your Lordship.
You say both sides are represented. Okay.
Oblige.
Number 28.
Here, Your Lordship, learned amicus curiae, Mr. Tison, she was present during morning hours, but she left.
Just a moment. Just a moment. Application is made. The application. ठीक है okay.
Here, Your Lordship, Mr. learned amicus curiae, Mr. Tison, he was present during morning hours, but he now left the court premises because he was he was being unwell. So next step maybe I'm police state. He informed me.
Mr. G. Tarot, an additional public prosecutor, has submitted that Mr. Tison, the learned amicus curiae, had informed him that he was feeling unwell and left the court.
Yes.
He said, don't the matter stands adjourned today. List after 2 weeks on a date to be fixed by the office.
It may be fixed for tomorrow, so he instructed me.
Tomorrow.
If there's any accommodation can be done. Or day after.
Yes, yes. Yes.
376.
No, also POXO.
No. Also dropped.
POXO was dropped.
Yes.
But if it is 376, is it not required to give notice to the informant? I think in 376 also notice is required to be given to the informant.
Yes. It was duly served.
It was so.
Yes. Through OCPS NAMSAI. There is a WT message sent serving notice.
Next one. Quickly. We take note of the fact that this court by order dated 28/4/2023 directed that the complainant be implemented as respondent number 2 and a notice be issued to the officer in charge of Namsai Police Station. In this regard, the Mr. G. Tagore and government, APP has referred to the WT message received from the officer in charge, Namsai Police Station, indicating that notice was duly served to the respondent number 2 on 24/5/2023. Next paragraph. As the appellant has been convicted for committing offense under section 376 IPC. Court is of the considered opinion that legal aid counsel be appointed to represent the interest of respondent number 2. Accordingly, the court is inclined to appoint. Give a name from that list. Make down the list, man. Legal aid counsel. This one as legal aid counsel. वो उसको अभी अपन किया है एक केस में और किसी का नाम दीजिए जाता नहीं है What is Ms. Ananju, that is legal aid counsel. Represent the interest of also. So the registry shall inform the learned amicus curiae of our appointment as our appointment in this matter. The present respond number 2. And such communication be also recorded in the office note. And this record. Paperwork is ready.
Yes,
You can also
ready.
serve a copy of paperwork, or photocopy of the paperwork to the legal aid counsel for respondent number 2. Except and acknowledgement. Next paragraph. This term. We make it after 2 weeks. Let us both wait. Just after 2 weeks. On a date to be fixed by the office.
File the office. The registry shall inform the legal advice to the present respondent 2 in the hearing which is scheduled after 2 weeks. Acknowledgement to the effective part entered in the note sheet. We are giving her information that will be hearing matter will be heard after 2 weeks.
Yes.
Otherwise, she will not be prepared.